Welcome to part 2 of What is Patent Prosecution? To review, in the first video we covered the first 3 phases of patent prosecution, which include developing an overall IP strategy to cover your invention, building a claim set that covers the full scope of your invention, and preparing your patent application specification. Next, the 4th main phase of patent prosecution involves creating drawings to cover the scope of your invention. The USPTO has a massive and detailed manual for patent examiners to follow during the course of patent prosecution, called the Manual for Patent Examination Procedure. In this manual, which you can read online, there are detailed guidelines for all parts of the patent application, which include drawings. The MPEP rules for drawings cover things like ink color, type of paper, size of paper, exploded views, partial views, arrangement of views, margins, shading, symbols, legends, numbers, letters, and reference characters. In a nutshell, there are literally thousands of ways that you can screw up drawings. So not only do you want to have a solid strategy to deploy drawings that cover the entire scope of your invention, you need to make sure that your drawings comply with all the numerous requirements of the USPTO. The best way to do this, of course, is to have the help of an experienced patent attorney. Once you have your IP strategy, your claims, your specification, and your drawings complete, the next phase is to finalize and file your patent application. When you file your patent application with the USPTO, you have what is known as patent pending.
And as you can see, the unique dents in my invention perfectly match the contours of the human vertebrates. Patent pending, patent pending, patent pending.
When you mark your invention patent pending, you signal to the rest of the world that you have rights of priority in your invention and that copying your invention might have serious legal consequences. Filing your patent application seems simple enough, but starts the clock on many important deadlines that you need to be aware of. If you file a provisional patent application, for instance, you only have 12 months from its filing date to file a non-provisional patent application claiming priority back to the provisional patent application. Otherwise, you might lose all patent rights in your invention. Then, when you file a non-provisional patent application, there is a whole host of things you need to worry about. For instance, there are deadlines to file an information disclosure sheet. You need to make sure your inventorship is correct. You need to make sure that your declarations are properly signed. You need to make sure that all of the parts of your non-provisional patent application that are required to be filed by the USPTO are present. You need to be prepared to respond to USPTO communications with arguments as necessary on inflexible deadlines. In summary, filing a patent application, while an important phase of patent prosecution, is just the start. You should have help from an experienced patent attorney to ensure that your patent application filing puts you in the best position to acquire and defend patent rights. The final phase of patent prosecution involves the process of presenting arguments to the Patent Office stating that the claims in your patent application covering your invention are eligible for patent protection. Generally, when the USPTO receives your patent application, they will reject some or all of your claims. This isn't necessarily a bad thing. Receiving a rejection can help indicate the boundaries to which your invention can be claimed. To effectively respond to the USPTO's rejections, you need to understand the law and reasoning behind those rejections to prepare an effective argument. A first step you might take when you receive a rejection is to conduct a phone or video interview with your examiner. During the examiner interview and through other correspondence with the USPTO, you can better understand the rationale behind the rejections and better present an argument as to why your patent claims are valid. More often than not, an examiner rejection will be based on some assertion that the claims covering your invention cover something that isn't new or novel, or covers something that is merely an obvious derivation of something that already existed in the prior art. Typically, to overcome this type of rejection presented by an examiner, you need a combination of argument as to why your invention as claimed is actually new or novel and also non-obvious. And also you typically need to amend your claims to avoid the scope of the prior art cited by the examiner in support of the examiner's rejection. A primary objective during this phase of the patent prosecution is to achieve a compromise that brings you to a state of allowance for your claims in a way that covers the scope of your invention to add value to your business. None of this is easy, and you need an experienced patent attorney to help you build a strategy to respond to rejections and effectively communicate with the USPTO during the course of patent prosecution. I hope you found this discussion of what is patent prosecution beneficial and informative. If you have any questions related to how the patent process can benefit your specific situation, feel free to get in touch with Rocky Mountain Patent by visiting rockymountainpatent.com, and you can set up a free initial consultation. Thanks very much.